Supreme Court was hearing oral arguments today, and while maybe a lot of us were wishing they would hear the case on Obamacare again, maybe reconsider, they were actually talking about a different case today. This is Fisher versus the University of Texas, a question of whether race can be used as an admissions criteria at U.S. colleges and universities. Here to tell us about the Supreme Court's oral argument is our own Collin Levy in Chicago. Collin, thanks for joining us.
Hi, James.
So I'm not sure if we were able to get a case today, but get a read on where the justices are going in the case today. But it basically comes down to this question of Abigail Fisher, who was denied admission to the University of Texas, says, look, I had superior academic credentials to some minorities who were accepted. My rights under the Equal Protection Clause of the 14th Amendment have been violated. Did you get a sense from the debate today, the discussion today, what the justices are thinking of this claim?
Well, I think everyone is watching Justice Anthony Kennedy in this case, because he's the perennial swing justice, and he has sort of gone back and forth a little bit on this question of diversity. Now, he has routinely been against real, true race preferences at schools, but he has sort of at times opened the door to the idea that diversity can be a compelling interest. Now, the big Supreme Court case that everyone's looking at here is 2003's University of Michigan case, in which they considered whether or not the law school could use racial preferences, and Sandra Day O'Connor agreed there. And Kennedy notably dissented. So everyone was watching today to see what he would say. And in this case, he also seemed skeptical of what the University of Texas was doing. And he said at one point during the oral argument, so race is the biggest factor here. And that sort of, it seemed to indicate that he might be skeptical that instead of being used sort of in the panoply of many different factors that a university would consider, that here it was the overriding factor.
Okay, so if I've got this right, there's been, I think, even among liberals, a consensus that strict racial quotas should not be acceptable, but it's a question of how much diversity can weigh in these decisions, or is this really about whether diversity as a value in itself needs to be proven? What is the
No, that's exactly right. And there's this concept out here, an amorphous concept of critical mass. They call it critical mass. And that is exactly how much diversity is enough diversity, in essence. And one of the things that the University of Texas has said is, hey, we had this top 10% law that brought in more minorities on campus, and in fact, really got the diversity on campus up to higher than even before they'd had racial preferences. But anyway, the question that they then said is, but, some of the classes, we have smaller class sizes, and now we might have an English lit class that actually doesn't have a representative number of minorities. And that's something that Justice Roberts was very interested in during the oral argument today. He said, I'm hearing all this stuff about, about this concept of critical mass, but no one's really adequately explained to me why it's important. There's this sense, I think, among the justices and many watching this, that there's constant moving of the goalposts.
Okay, yeah, now, and I'm not going to ask you to predict the outcome from the oral argument. We've learned not to do that. So thanks for that update, Collin, and we'll look forward to the decision later this year.
Thanks, James.